So, £5 million of taxpayers' money paid to a burglar in prison. What's going on? And was that suitably clickbait enough? Because I was really trying to lean into it. But yeah, it's an interesting story, and it gives me a chance to talk about some just general topics. So first, the story. As you may have read, there was a guy on remand in prison. He was a sort of long-term burglar. He's got something like 70 previous convictions. But while he was in prison, he was assaulted by somebody who was in there for the M word, because they decided, hey, you're in here for stabbing lots of people, let's put you to work in the kitchen. And, you know, this guy ended up with some very, very serious injuries. So he sued, effectively, the Home Office as being responsible for prisons, and he's ended up with nearly £5 million. But how did that come about? Well, partly it came about because the Home Office just admitted liability. So the court case was actually about how much money he should get. So how did he sue? Well, he sued in negligence. So just to explain what negligence is, to prove negligence, you have to establish three things. That the defendant owed you a duty of care, there was a breach of that duty of care, and as a direct consequence of that breach, you suffered a loss, in this case, a permanent personal injury, which also has some financial aspects to it. But who do you owe a duty of care to? It's what we call the the neighbour principle. Who is my neighbour? The test generally is, who might be affected by my actions? Who can I reasonably foresee? A classic example is everybody using the road, all drivers owe a duty of care to everybody else on the road, and indeed everybody on the road owes a duty of care. That's not always the case though. Say for instance, the police are negligent in an investigation. They've got a tip off about some bloke going around offing people, and they decide to have a cup of tea first. And while they're having the cup of tea, that guy comes and gets you. Can you sue the police? Well, no, as I've explained in a previous video, generally speaking, the police don't owe a duty of care to the victims of crime, except in some very special circumstances. You can also have a contractual duty of care. Say I invite you to come on my experimental submarine, and we're going to go down and look at the Titanic, and you pay me lots of money. There's a contractual duty of care there, because, it's the same, you owe your paying customers a duty. So in this case, what was the duty of care? Well, the prison service, under the auspices of the Home Office, they owe a duty of care to people in prison. Now, I know people might say, well, if you can't do the time, don't do the crime. But the fact is, when you are sent to prison, you're either being held there on remand, and I'll get all pedantic and say, so that's technically a jail, or you are serving your sentence. When you're serving your sentence, the punishment is the deprivation of liberty. It's not that you might end up just reenacting Scum, the rather excellent film and TV film. Two of my favourite films. But yeah, while they're looking after you in prison, they owe you a duty of care. And also, remember, this guy was on remand. He hadn't been convicted at the time, although he subsequently was convicted and ended up... He was sentenced actually to 9.5 years, but they reduced it by 3 years to take into account the rather unpleasant time he'd had while he was on remand. So in this particular case, the Home Office accepted they owed him a duty of care. What was the breach? Well, maybe they could have fought this, but they said the breach was they didn't properly assess the other guy and recognise how dangerous he was, and they just put him in an environment where he had access to knives. So the argument is it was reasonably foreseeable that somebody in that position might end up doing something to somebody. So that was the breach. And as a result of that breach, did somebody suffer a loss? Well, yeah, I mean, this guy did end up with life-changing injuries. It was a really sort of brutal assault. And, he now will, be disabled for the rest of his life. But even though they'd accepted liability, they said, well, we'll still have a trial on what we call quantum. It's not uncommon that, especially in personal injury, to have split trials. Because sometimes somebody might admit liability but deny, say, well, hang on, what you're claiming is too much, we need a trial on that. Sometimes they might accept and say, well, yeah, all these injuries you got, we accept that, the damages for that would be this fixed amount, this particular amount. However, we say we're not responsible in the first place, so let's have a trial on liability. And sometimes you'll just have the trial on liability first anyway, even if you're denying both. It's like, well, before we waste all the time, assessing the sums and looking at your life expectancy and what, how we might need to modify your house, let's just first of all have a trial to see if they're even responsible for this. But like I say, in this particular case, the Home Office accepted liability. So when it came to damages, we split it into two different types. There are general damages and special damages. General damages are the amount you get just for the pain and suffering. It's the non-sort of tangible damage. So it's like things like pain, suffering, indefamation, hurt feelings, all that sort of thing. And how do we establish that? Well, when it comes to personal injury, there's a book called Kemp and Kemp that just looks at what all previous personal injury payouts have been for different types of injury. And then you pick the figure there and you adjust it for inflation and all that sort of thing. There's also judicial guidelines now where you literally look and go, okay, you suffered this injury, you've lost the use of an arm, that's worth this much, you've lost the use of a finger, you're deaf in one ear. These are the sorts of things. You can also get things like for just the scarring and stuff like that. Rather bizarrely, when it comes to things like facial injuries, they look at how big an effect it would have on you. So, a supermodel would probably get paid more than me because they'd probably go, well, come on, it's hardly going to make any difference to you, mate, is it? Whereas, if it's Naomi Campbell, not only is that her, career, it's the fact that she had more to lose. So seriously, that is something they take into effect. But you've also got then special damages, and that's the quantifiable losses. So things can be things like medical treatment, therapy, adjusting your house, so you need a wheelchair ramp now. I mean, the idea with damages though is, in this country, unlike some jurisdictions, we don't really have the concept of punitive damages, where they award damages effectively as if it was a fine. The idea here is that the damages just put you back into the position you would have been had the loss not have occurred. And it's a bit arbitrary when it comes to general damages. I mean, it's like defamation. It's like, why does sort of £80,000 suddenly put you in a position where you're going, oh, okay, then I'm not that bothered that it happened. And, with personal injury, I mean, you lose a leg or something. Can any amount of money make up for that? Well, according to the law, yes, it can. So the idea is that you walk away going, not sort of like, oh, I'm feeling a bit disappointed, I wish that had never happened, but also, wow, I'm really glad that happened, I'm quids in here. So that's the sort of general damages aspect. But with special damages, they will look at things also like, loss of earnings, loss of future earnings. I mean, in this particular case, it was very interesting because this guy was claiming loads for loss of earnings, and the Home Office made the not unreasonable point, look, mate, you're a professional burglar, and we're not going to compensate you for that. Because that's one thing, you can't be compensated for, illegal earnings or anything. It's like, I was a really successful sort of like gang leader until all this happened, and now I can barely get into the bank, let alone sort of go in there, rob it and leg it out again. And he was putting in things like, I was earning £800 a week before this. It's like, well, let's see some receipts, mate. But that's how with loss of sort of past earnings, it's sometimes if it's really obvious, it's like I was in hospital for 8 weeks and I was out of my job for 8 weeks. This is how much I lost, and then you take into account you get the deduction for, well, were you receiving any benefits while you're in hospital? They adjust it all that. So the idea is you're no better off, you're no worse off. When it comes to future earnings, they sort of predict your career path, and I've done some cases because I used to do little military stuff, where it's things like this person would have been promoted to major within X number of years and would probably have retired as a colonel on this pension. Sometimes it gets really interesting. Sat in on a case once where it's a professional footballer who had basically had a career-ending tackle, and he was suing on the basis of that. And what was interesting about that is they got this expert And I always say, when I do the advocacy training to people, use your props if you've got them. Get your witnesses to use props. And this guy brought a complete working model of the human leg with all the bones and all the tendons were sort of there with in rubber. And as he was explaining the injury, he sort of had the leg there and he went, well, the tackle came in like this and it caused this injury. And he just whacked this fake knee and it sort of and lodged out of place. And I saw the judge go, phew. And that's when I went, this guy's going to win, and he's quids in. But they were having to predict, what was his career? Would he have ended up playing in the Premier League, and how much would he have earned? So that's the sort of calculations you have to put into all this sort of thing. They also predict how long you would have been earning, how long would you live? And in this, they do it all by actuarial tables. It's like, well, you're currently a 35-year-old bloke, you're not exactly in the best of health, you smoke 20 a day, and you live off chips. And in this case, they all agreed, you're probably not going to make it past 65, mate. Because when it comes to sort of future compensation, generally speaking, they don't pay it, going forward. You get a lump sum, and it's all calculated that here's a lump sum, and if you invest this, then you'll be able to draw down on the interest, and then eventually you'll draw down on the capital, and just as you've got down to zero on your bank balance, you will snuff it. That's how they establish all that sort of thing. When it comes to what you can claim for, it is things like hospital treatment, therapy. You're under a duty to mitigate your loss. That's just generally in all claims. Say for instance, you've got a diesel tank, and I bump into the tap and I leave it dripping, and you come along and find that. You can't just go, well, brilliant, I'll let the tank empty and sue him. If you can just turn the tap off, you're supposed to do that. And similarly, it might be, well, you've got an injury, but if you have this physiotherapy, that will alleviate it, so that will mitigate it. You can't necessarily force people to go on the NHS, though. If they choose private treatment, they can often argue, well, that's justified, because I don't want to be waiting 8 weeks between appointments, so I'm going private. Also, now, you can claim for carers, and if you actually employ a carer, you need a home help now to sort of, look after you and cook for you and bath you and that sort of thing. If if you're just paying somebody and they just go, this is the invoice, that's fine, that's easy to quantify. But what if you've got a family member who just does it gratuitously? They just take care of you. In that particular case, there is actually, they can award damages for that person in lieu of wages, because they accept that they are actually doing a benefit. And interestingly there, even though technically those damages are yours, you are holding them on trust for that person. So say for instance there's a bankruptcy, they can't come after that element of the damages. I mean, generally speaking with bankruptcy, you can't claim the general damages because that's for your pain and suffering, but you can claim, you can go after the special damages because that's just financial, and in the same way they could garnish your wages or seize your house. The same rule applies. But also, if you're caring for somebody and the person doesn't hand over that element of the money, you can actually sue them for that. But were there any defences that perhaps the Home Office could have run? Well, we have a thing called ex turpi causa. The idea being that you cannot profit from your own wrongdoing. But that's something like, say you go in to rob a bank and you trip over on the doorstep. Arguably there you wouldn't be able to sue. Although, if it was like a crooked step, you still could. I mean, this is the bizarre thing. Under the Occupiers Liability Act 1984, you owe duty of care even to trespassers. Although it's just a duty of a basic common humanity, don't put bear traps down or leave any holes uncovered and things like that. But with ex turpi causa, usually it's, the loss has to be a direct consequence of something like that. I mean, the classic one you quite often get is insurance companies won't pay out for people who are injured when they're drink driving, because they say, well, no, it's entirely your own fault, but for you legally drink driving, you wouldn't have been injured. We also have what's called contributory negligence. So, you are, yes, I have caused you an injury, but that injury is worse than it needed to be because of something you did. And again, a classic example is, not wearing a seatbelt in a car accident or not wearing a crash helmet on a motorcycle. I mean, theoretically, they have to actually show that it did make a difference. And sometimes that is very possible. It's like, yeah, you suffered a really serious head injury, and the experts all agree, had you been wearing your crash helmet, that wouldn't have happened. Sometimes, though, it's a little bit just, you know, they put a percentage on it, because it's like, well, we can't quite work out how worse the injuries were because you weren't wearing a helmet or a seatbelt or something, but we'll knock it down by 20 or 50, 15% or something. In olden days, as I keep saying, contributory negligence used to be a complete defence to a claim. If you could show that somebody had done even the slightest thing wrong themselves, that got you for the hook completely. But people said, well, that's not really fair, is it? Because just because somebody has been a little bit negligent, it shouldn't negate the fact that you also were negligent and they did suffer an injury. But yeah, in this particular case, so that's why he's got the 5 million, because once the duty of care and the breach was accepted, they just looked at it the same as they would any other, personal injury case, any other sort of negligence claim. And the mere fact that he's, quote, a wrong 'un, didn't disallow him his damages. So why is it 5 million? Like I say, these are really serious injuries. He was living in a rented flat up some stairs, and they agreed and said, well, no, he needs to be living like in a bungalow now, and it needs to be all adapted. I mean, I suppose it's an interesting one now, because what if he'd been homeless? To put him back in the position he was, it's like, well, you didn't have a house in the first place, so why should we build you one? And it gets into all sorts of horrible, messy things. I mean, we always do say, it's always cheaper to kill somebody than cripple them, because, paying like somebody's potential loss of earnings for the next few years might be a lot cheaper than having to sort of, modify their house and pay for treatment for the next 30 years. It also gets really bad with children, because children tend not to bring any money in, because obviously families can sue. If somebody, is unalived, as the kids say, the family, the estate has a claim, because it's like, well, he was providing for us. But what if somebody who wasn't actually bringing any income in, like children? I mean, I know it sounds awful, but the argument is, well, actually, financially, you're better off, because you don't have to feed this child now. So you just get the general damages bit. There's like the Fatal Accidents Act caps how much you get, and it's a sum of money and the funeral expenses, and it's not a particularly high sum of money for the family. I mean, correct me in the comments, because I didn't check. I should have checked this before I came out, but it used to be about £12,500 just for like the loss of a loved one. I mean, that might have changed now. You also get to rather strange things where, what if you're paying out for somebody, you've just agreed to pay some damages to somebody, and then they get hit by a bus? Do you have to continue to pay? And there have been cases where they've gone and clawed back the money and said, well, we put this lump sum in on the assumption that this person would make it to 65, and he didn't make it 2 weeks after the trial, so we want all that element of the money back. And that has happened. But there you go. So, gave me an excuse just to talk about negligence and personal injury generally. So as always, hope you found that vaguely interesting, vaguely useful, vaguely informative, hopefully not too infuriating. Where am I today? I'm back at Ale and Cakes Mine, or Cakes and Ale Mine. Since somebody in the comment pointed out, and that's just an old saying meaning everything's going great, because I told you this was a bit of a surprise success story, this mine, and apparently that's why they called it. It's like, everything's coming up, cake and ale, or cakes and ale. I really like that now, but it's a lovely spot. It's been siling it down all day, so this is about a 10-minute break, or 18-minute and 8-second break, where it actually wasn't. But now I'm going to go, because it's also very windy and cold, so I'm going to go somewhere a bit warmer to edit this.